are adopted by the state authorities, that is not in terms of the policy. That is what they say.
That is not in terms of clause 8.3.
Right, sir.
That is the only.
That is it. But only after participation and only after the draft list was prepared, they have challenged it.
No, rightly. They challenged. They could not have challenged before publication of
Right.
draft.
That I don't say.
Because they must have presumed
Sir, the only question is
that the states have act in accordance with what was there in the resolution.
Sir,
Okay.
that matter still, we have to argue that matter. That's another part. But so far the implication of party is concerned, if you have come to the court of law after the draft list was prepared, had the draft list has been prepared, their names could find place, they could not have come. But the draft list has been prepared. After that, they have come to the court. Now the question is whether, at least in a representative capacity, all could not have been made parties. At least one or two could have been made a party.
All
That
right.
is what the law.
In any case, can the court now, appellate court should interfere in view of the clear provision under the clause 8.3 of the resolution.
Such that I will address so far the 8.3 is concerned.
And the direction is only to the extent that you prepare district-wise merit list.
Sir, my point is there. You also look to the written argument which was submitted by the state before the Honorable Single Judge I have given. You also look to that. That is a page. They have written one paragraph also. You know, they have made an attempt to prepare a state merit list as well as the district merit list. In either of the two,
We appreciate your submission that in either of the two lists,
they are not.
appellants could not have succeeded.
Right. They have not qualified, even if they have not secured the mark which has been secured by a candidate like us, the last person who has been selected. That is page 77.
All right. Then in that case, the state could have simply followed the direction issued by the single judge by preparing district-wise list in terms of clause 8.3.
Also, far as we are concerned, the whole problem is now the once that will be the judgment of the Honorable Single Judge is implemented, so far the casting of the list of the recasted, then we'll be nowhere and we'll be affected. We are adversely affected.
You may be affected, but can you make a submission? Can you make a submission against clause 8.3?
Sir, I am not. That is not. I have not made any attempt to make a submission against clause 8.3. I will show that. But my first point before your lordship is, my submission is that implication of parties, because that is very fatal. Even the Honorable Supreme Court has said,
Suppose we set aside the order.
Right, sir. What argument I can advance? That your lordship may put the question. Yes, sir.
What directions? The stipulations in the resolution.
No,
Like
I cannot. I must go by the
Would your lordship then permit me? Because I have filed an appeal also. Kindly see, my lord. Kindly see page 5.2 of the judgment. I'll refer to the page my learned friend is referring to. Page 5.2 of the judgment. Internal page 26. Running page 253.
Yes.
My lord, I had argued that the petitioner's names do not find in the draft merit list. Now, let me tell you, lordship, the context of this. There were 20,000 posts. Now, there were 85,475 candidates, out of which, my lord, 18,788. May I tell you, lordships, again? I'm sorry. There were 85,475 candidates for 20,000 posts. Now, 18,788 called for document verification. And then, my lord, total number of people who appeared were 16,217. Now, post document verification after the draft list, today we are at 15,815. Today, if we have a 15,815. The petitioner's name did not find place in that 1627. So we had submitted before the learned single judge that in any case they are not qualified because they are not there in the draft list. So therefore they have no locus. Whether it will be 8.3, whichever way, they have no locus. The single judge, my lord, with great respect, did not address that. That is one point. Now on 8.3, let me straight away come to 8.3 minutes. And that your lordships will find in this writ petition. Let us see, my lord, that is, if your lordships kindly see, my lord, the resolution is at page.
We are there at
Lordships have it, my lord.
8.3.
Your lordship may see, my lord, before your lordship sees 8.3, kindly see, my lord, there is a clause 3 which says advertisement. My lords have it.
Yes.
So OSEPA on behalf of the school and mass education will publish an advertisement in a widely circulated ODI English daily newspapers inviting online applications for intending application for engagement as so and so. Now, my lord, kindly see 8.1. My lord, what has been missed out is really 8.2.
Yes.
My lords have 8.1, my lord.
Yes.
Selection procedure. Publication of master list. After expiry of the last date of submission of online application forms, list of candidates for each category with respect to their first preference districts as submitted by them at the time of submission of application form will be published in OSEPA website. Information on subsequent preference districts of each candidate will also be available in OSEPA website. Now, my lord, if your lordships have that application, which an applicant makes, he gives a preference of 30 districts. So it is not as if one applicant is saying, I am only giving Baleswar. He gives 30 options. 30 options. Now let us see, Lord, what is 8.2.
In the order of preference.
He gives. I'm grateful. But he knows that he will be fitted into one of those 30s. That's the point. When he is giving 30, he knows he will be fitted into one of those 30s.
So is this your submission?
Yes, ma'am.
The list which was prepared, that was under 8.1. And
The list was-
stage had not reached. No, this is not your submission.
My lord, now comes 8.2. No, that is not my submission. 8.2 says an online computer-based test will be conducted by OSEPA, an authorized agency, as per the syllabus contained in the advertisement, to be published before the recruitment. My humble submission to your lordship is following. This online computer test is a test to determine your merit. And my lords, for determining the merit of the applicants, the single judge says, my lord, the Honorable Single Judge A does not refer to 8.2. B, he says that merit has to take a back seat, preference of district has to take a front seat. That's the short point. May I say it again a minute? 8.2 was inserted to hold a computer-based test amongst the applicants to determine their merit. 8.3, if your lordships read 8.3 along with 8.2, the inescapable conclusion is that merit has a very important role. We are selecting teachers to teach students. And if your lordship sees, my lord,
No, how do you say that? This is
Yes.
the finding of learned single judge.
Lord, now, kindly see, the three lordships have read 3.
So whatever merit list was prepared
I'm grateful.
by you
Yes.
was on the basis of this 8.2.
8.2. But there are 2 submissions. 8.2 will select a candidate. 8.3 will say, I will allot you this place. And you have given me a list of 30 in your application. Now, kindly see, my lord, how does the learned single judge deal with this?
No, but did you prepare a
Yes.
draft merit list?
Let me show it to your lordship straight away.
The document is to the district to explain.
No, the first one.
As per your draft.
Kindly see, my lords.
Page 30.
Then please let me see the first one. Now, my lord,
Yes.
my lord, this list has not been challenged and they have appeared pursuant to this list in the examination. With reference to certain media reports regarding the recruitment of junior teachers, schematic 1 and 2, it is to inform you that so-and-so has been entered into an MOU with Odisha school. You may skip all that. Let me read it. The CBT was conducted in accordance with the requirement of so-and-so. The resolution provides guidelines for engagement of junior teacher schematic, including application, submission model, eligibility age, reservation list, certain criteria of selection process, methodology of finalizing the merit list. Response query management was done and all objections were addressed. After conducting the computer-based test, EDCIL prepared the results as per the guideline provided in the resolution dated so-and-so to the authorized designated officer of OSEPA. Now kindly see, my lords, kindly turn to the next page. That is the list. That is the list that was prepared at the first instance. Now if my lordships will kindly see, my lords, kindly look at serial number 1835. Extreme left. My lords have it.
1835,
Serial number, page 39.
page 39.
Just after that page.
First number.
Yes.
This is an abstract. Now kindly see, my lords, the person's name is, the roll number is there, application number is there. If your lordship sees serial number, then application number.
Yes.
Then kindly see, my lord, roll number. Then kindly see junior schematic category 1, science, Now, my lord, what your lordships are seeing is the merit list of the various candidates. And once the merit list is prepared, then whoever is fitting into which district it has given, the submission to your lordship is merit has been given preference in preparing this list. Let us say, my lord, I prepare a merit list of first 100. So I now pick up who are the first 100 candidates. And then I try to fit in their district preferences accordingly. What the learned single judge says, my lord, with great respect, that you first give them the district they want. And I will show that to your lordships. Merit cannot prevail over the district preference. Now, that is the short point which your lordships have to consider, my lords. Kindly see, my lord, what is the finding of the learned single judge. Okay. Page 8.8. My lord, lordship may see first, my lord, paragraph, page 5, the internal page. My lord, 1 second, my lord. Your lordship don't mind. Page 2, Lecture 6, and or consequential district and category wise list by segregating the names of each 30 districts so produced in a seal cover before court have not been prepared in terms of the provisions contained in para 8.3. The resolution placing reliance on the decisions of so and so I cited this court is inclined to interfere with the draft result sheet as well as the district and category wise list for each of the districts, segregating the names so produced before this court in a sealed cover. My lord, the next paragraph. The stand taken by so and so that the merit list is the sole criterion. Now, this is the argument that merit is the sole criterion for selection of teachers, and that has been followed is not acceptable as it runs contrary to the provisions contained in para 3 of the resolution. Taking into account the submissions of so and so, the list of successful candidates have been prepared. Taking into account their performance and merit, it can be inferred that the stipulation contained in 8.3 of the resolution has not been followed. Since the provisions of 8.3 is very specific, that selection of candidates only basing on their merit, irrespective of their district, of their preference, given for a particular district, is not sustainable in the eye of law. This court accordingly is inclined to quash the draft list published under Annexure 6, and so also the district and category list published so and so, before just produced before this court. While quashing the list, this court directs the OP number 3, but this is important, to prepare district-wise, category-wise draft merit list in terms of the provisions contained in 8.3 of the resolution dated so and so. After such publication, the district-wise category shall proceed with selection. So therefore, millards, what the learned single judge says is that you forget your 8.2 CBT exam, you forget your merit list, give them as per district preference, namely, irrespective of what mark he has secured in the CBDT list, if he has given Bhadrak as a preference, tabulate all Bhadrak. This tabulation on the basis of their merit is not in conformity with 8.3, and without saying that why, then what was the basis, what was the reason for 8.2? There was no necessity to have a CBDT test, because everybody will be given as per. So in other words, millards, I will now select teachers who are less meritorious and give them the district preference and appoint them, and leave out teachers who are more meritorious. Just 4 lines of a judgment of the Supreme Court, millards. Just give it. Did the rage?
Two invented. 2, 10 and 12.
This is the one.
No, paragraph 2, 10 and 12.
My lords, may kindly see paragraph 2, millards.
Yes.
This is Anmol Thakur, Kumar Tiwari. This was also cited.
Yes.
But this was also cited, millards.
Yes.
A high-level committee was constituted by the state government to examine the irregularities in the selection process. The report was submitted by the DIG police personnel, state of Jharkhand, in which it was found that select list was prepared wrongly by ignoring the merit of candidates and giving them undue preferences given by them. Your lordship may straight away come to para 12 minutes. Just 4 lines. This is at page 428. My lords have it, minutes.
Yes.
Para public employment should be on the basis of merit. Appointment of persons with lesser merit, ignoring those who have secured more marks, would be in violation of Article 14 and 16 of the Constitution. I rest my case there. The submission to your lordship is that 8.2 read with 8.3, read with Article 14, read with Article 16 is the real answer. The learned single judge says, millards, that you ignore 8.2, forget merit, only go by 8.3, even though 8.3, millards, go only by 8.3, I am quashing your select list, which is based on merits. Now you give them as per their district preferences. Net, people who did not even qualify, like the petitioners, they were not in that list, or people who are down below, will now get in. And people who are more meritorious, they will be left out. In short, that is our case. And today, if I have to continue with this process, I will be appointing about 12,000 candidates roughly. But the point is, milord, merit is going to be compromised.
No, but that you have to prepare a merit list on the basis of
There is no difficulty there.
8.2.
Well, there is no difficulty.
That cannot be compromised.
Well, let me answer that question, subject to your lordship's kind consideration. It is this. I have shown your lordships a master list. Now that master list, when this question was posed to me, I told the learned single judge, and I did file without a district-wise list. But what the learned single judge has said is that this is also wrong because you have gone by the, suppose not Bhadrak. Let us take, for example, Bhadrak. I go by the candidates on the basis
No,
of
that
merit.
would have been a situation
Yes,
had the selection process been district-wise.
Yes, I'm grateful.
The
I'm grateful.
matter would have been different.
I'm grateful. Your Lordship, answer my question.
In fact, as per the resolution,
Yes,
you had gone for say competitive examination.
I'm grateful.
Competitive test.
I'm grateful.
To have a merit list on the basis of the vacancies which you have.
I'm grateful.
And then you were required to prepare a merit list district-wise, of
Correct.
course, keeping in mind their preferences. So that was all.
So, my lord, what did I do? Your Lordship saw that page just now, which my learned friend showed, my lord, that page. Kindly see, my lord, kindly look at page 39 again, my lord. And 30 is what they gave. Who paid is it? Is it there?
Preferences, you prepared a merit list.
I'm grateful.
And you allotted a particular district based on the preferences.
I'm grateful.
Or the candidates already selected might have a grievance that I have not been allotted a proper district.
No one has come.
Therefore, a person may claim
Correct.
I ought to have been given
Yes.
a puri instead of badra.
I'm grateful.
All right.
I'm grateful.
So this can be this thing. But if you prepare a merit, even if you prepare a merit list,
Yes.
district-wise,
Yes.
a candidate may say that my preference was this, my first preference was this, I had better merit position. Still, someone of less merit has been given.
Correct. You will be absolutely.
These circumstances can emerge.
Can emerge, no difficulty. Because he knows when he is applying that I will be considered one of those 30 districts. That is why he is giving 30. Now kindly come to page 39. What has fallen from your Lordship, my lord, is exactly what page 39 is. I prepare a merit list. I give them allocation. One of the merit list persons can come and say that, look, I could have got Puri, you have given me Denkanar. Now,
That is therefore it is draft.
therefore it is draft. And
Maybe.
no one who has qualified, who is a part of the merit list is before your Lordships, complaining this. But I bow down to what your Lordship is saying. But if your Lordships hold, as the learned single judge has said, that district-wide preference will prevail over merit, I have no case. I have no case. But if 8.2 has to be given some meaning, and pursuant to 8.2, one test has been held, and based on the mark, a merit list has been prepared, and then districts are filled up, and somebody who has qualified, who is in the merit list is complaining, would be a question your Lordship may consider. Here,
Why this district-wise list was placed in seal cover?
because my learned single judge said that this is not a district-wise list. So what we did, we broke this list into districts. For example, if your Lordship sees page 39, just as an illustration, suppose there are 5 Mayurbhanjas. We put all Mayurbhanj in one list. We put. But he said, no, this is not good enough. Because you have prepared this list. You have prepared this list on the basis of merit.